Healthcare professionals need to be advised by their leaders, and it's critical that healthcare leaders and executives, board directors, set the tone for how their hospital or healthcare organisation will respond when something goes wrong. If the board and the executive promote open disclosure as a key part of ongoing patient care, the fact that there may be litigation, which could occur any time, sometimes years after the event, should be in irrelevancy. If the board and the executive, however, are afraid of saying the word sorry, if they're concerned about the potential litigation and that is the tone they're setting, clinicians at the coalface, they will be hesitant to actually engage with patients, particularly if their experience is that they get into some form of disagreement or trouble with their leaders. I'm a firm believer that healthcare executive and leaders need to be trained in this space and need to have a very clear understanding of their role and responsibilities, that they set the tone that open disclosure should be expected to occur. It's fundamental to the patient's care, and if the patient has passed away, to their family's experience, and that the medical legal implications of that need to be put aside. And that really does come from the board in itself. So the board needs to be trained in that space. They need to understand their professional responsibilities, accountabilities as a board director in this space. And at the end of the day, they need to understand that when they sign the attestation to against Australian standards, they're saying that open disclosure as part of standard one in clinical governance is happening, regardless of the medical legal implications.
Oh, I couldn't have said it better, Lois. And I think that whenever you are faced with a situation where you find yourself, I suppose, questioning whether you should be being that transparent or open or not because of the fear of litigation, I would encourage you to really just go back and reflect on the purpose of open disclosure, which we covered in a previous segment. The purpose is that it's a patient-centric, open, transparent approach in our care episode for the patient. Therefore, and that transparency and accountability still remains regardless of whether it's a situation that should result in litigation or not. And the other aspect of it is also that we're not just in any business. We're in the business of healthcare, which is quite different. And I think we've got to come to it from that perspective about the patient's entitlements. They are entitled to know what went wrong, just like they're entitled to know any potential side effects of a treatment or procedure that they're going to have. And I think the other that's also worth mentioning, Lois, is that an organization not being afraid to disclose that despite litigation can actually use that as one of their clinical governance or quality metrics to set up their systems in a way that minimizes the risk of clinical incidents happening. Because then obviously one of your outcomes is to reduce medical legal claims. And that's a powerful incentive for organizations and CEOs alike in terms of the emphasis that you put on clinical governance, clinical incident management, and open disclosure.
Well, indeed, Sydney, the facts are that if you want to just come down to dollars and cents, the insurers of the Australian healthcare market, particularly the hospitals, are all overseas based. Those insurers, primarily from the UK, absolutely endorse open disclosure as part of the practice, as you said, of good clinical governance, in addition to the preventative measures of incident management and developing recommendations and actions and implementing them. They see that good clinical governance with open disclosure as part of it reduces claims. In fact, they will offer cheaper premiums to hospitals with an established open disclosure process because they know the chances of claims are reduced. So it's the right thing to do clinically, it's the right thing to do morally and ethically, and it's the sensible thing to do from a dollars and cents perspective.
And we do know in the evidence as well that the more transparent and genuine open disclosure is, the less likely it is to result in a medical legal claim at the end of the day. So I think there's a lot of reasons and benefits as to why you would be upholding those principles.